Hello, my name is Tiffany Chevron, and I am an attorney with Michel and Associates. And today I have the pleasure of talking with Chuck Michel again about the recent Supreme Court nomination hearings of Judge Amy Coney Barrett and what it means for gun owners in California. We hope that you will watch part one of our discussion on the nomination hearings. And as we continue today, welcome, Chuck.
Good to be back.
Good to have you back. So let's get right into it. This is part two of us talking about the Amy Coney Barrett nomination hearings. And as we've often noted, a good judge knows that his or her job is not to legislate from the bench or to make rulings based on his or her personal preference of what the law should be, but rather the job of a judge is to take clear and original meaning of a statute or constitutional clause and apply it fairly to the facts of the case, regardless of whether that judge personally likes the outcome or not. So you see legal opinions from courts all across the country every single day. Why is this distinction an important one that we should all understand?
Integrity in the law is critical to respect for the law. So when the law is politicized, when the courts are politicized, that undermines the whole system and the belief in the way the system works. That's why federal judges are appointed for life. So they're supposed to be given some degree of immunity from that kind of political influence, but they still have their own human personal biases that creeps in. So to try and set a standard, a clear standard that courts have to follow, that's something that we'd be looking to the Supreme Court with Judge Barrett on it to do. So, I mean, I think that's it in a nutshell.
Well, I mean, let's talk about that, the political aspect of it, and let's talk about court packing specifically. So court packing is clearly a political tactic that's being used right now. It's in the news a lot. It's being used to influence a body that's supposed to be this non-political body. So how would a strategy of court packing in the Supreme Court level affect the ability of the court to hand down good decisions, in your opinion?
Well, the reality is the Supreme Court, there's the ideal and then there's the reality. The reality is that many courts are biased and unbalanced, and the Supreme Court is no exception. For years and years and years back throughout the New Deal, the court was very controversial in deciding whether or not certain things that were being done were constitutional or not. And the court has been expanded at times throughout history in order to have more judges appointed that will go along with one agenda or another. So that's, court packing is a bit of a uncertain term. If you expand the court to try and pack more liberal judges on it, that's court packing. You go from 9 judges to 20 or however many, so that you can outnumber all the conservatives who made it onto that court legitimately. That's court packing. I don't know if court packing is really the right description to describe the type of judge that gets appointed by any given president. I mean, Democratic presidents always try and appoint liberal justices and Republican presidents more conservative justices. That's always been the way it is. It's just that at this point, the balance is being tilted because Roberts is kind of wishy-washy on things. The balance is now with Judge Barrett's appointment being tilted more firmly 5-4, with Roberts potentially the 6-3 deciding vote. And that's what the Democrats can't stand. They're terrified that they might get Biden in as president. They might take the Senate. They might keep the House, and they'll have all those branches of government to do whatever they want to do, but then they'll have a Supreme Court that will stop them. And that's why they're fighting so hard.
Yeah, and let's be honest, Ruth Bader Ginsburg could have stepped down in a previous administration, but they chose to keep her in place, and so that's put them in a very precarious situation right now. That now they have to deal with another Republican nominee.
Exactly. This is it's a lot of it is, I don't want to say luck because I don't consider it lucky that she died, but I mean it's fate.
Yeah, it's fate, and it's strategy, how they strategize. So So I know we have been very, very busy at Michel and Associates and at CRPA over the past year. Can you talk a little bit about some of the cases that I think are affecting a lot of gun owners here in California? I'm sure they want to kind of know where those are and what cases are potentially going to be working their way up to the Supreme Court in the future.
Well, you know, we had basically the Supreme Court swept the decks last June when it denied review in the 10 pending Second Amendment cases. And then just Monday, it denied review in the last one that was pending, which is the Rodriguez case for the gun seizures by the San Diego Police Department. That case cert was denied in that case on Sunday. So there's no cases actually pending before the Supreme Court right now. Remember, for a case to get heard by the Supreme Court, you have to petition for a writ of certiorari, then the Supreme Court has to grant that writ. It takes 4 votes to grant the writ and accept the case for review, but it takes 5 votes to win the case once it's been taken. So this has always been the numbers game that we were playing, and we thought that when Justice Kennedy dropped off the court, that we would have that solid 5. Justice Thomas is leading a contingent there who is very, very frustrated. I'd even say angry how the lower courts have ignored the mandates from the Heller and McDonald decision and bent over backwards intellectually to distort the Heller and McDonald rulings to advance their agenda. But the cases so now the cases are working their way back up there again. We have the Duncan case, which is the one that everybody's paying attention to right now, because like the Peruta case a couple of years ago, where we got a 3-judge panel to declare California's May issue licensing scheme unconstitutional. That was a huge win. When you get the 3-judge panel on your side, you've accomplished something. Well, we got the 3-judge Duncan panel on our side, and they struck down the bans on possession and importation of magazines that can hold over 10 rounds. And I'll point out that part of the reason that we were able to get that case, get the victory in that case, was probably because the Trump administration has appointed a lot of Ninth Circuit judges.
Absolutely.
It used to be 2-to-1 liberal versus conservative justice on the Ninth Circuit. So you lost a lot of times because of that political bias and the numbers. That's why the Ninth Circuit was the most overturned circuit in the country by the Supreme Court. Now you've got more Trump appointees. It's really more 50-50. So again, the numbers change, the fate, the odds, whatever you want to call it, of getting a judge who will actually understand and appreciate your argument have changed. So we got a good panel on Duncan. Now the state, not surprisingly, is trying to take it en banc, which means they want to get an 11-judge panel to review the decision of the 3-judge panel, and they're hoping they can overturn that win of ours.
Let me ask you really quick. Let me just make sure we're clear. The lower court sided with the gun owners and said, yes, this law is unconstitutional. The Ninth Circuit 3-panel sided with gun owners and said this law is constitutional. And now we're moving on to potentially an en banc hearing where we hope that the full 11-judge panel will rule in our favor as well.
Well, yes, there's a prerequisite step, though. We don't think it's appropriate for the 11-judge panel to hear the case. This is not a situation where there's some kind of obvious error or abuse of discretion or some kind of obvious mistake made by the 3-judge panel. The reason that Attorney General Becerra is trying to get it in front of the en banc panel is because he wants to overturn it, because he doesn't like the policy decisions, he doesn't like the factual rulings, he doesn't like the legal interpretations. That's not really why you're supposed to go en banc. But again, it's political, so they may very well take it. But the prerequisite step, all we've briefed so far, is that it's not appropriate for en banc review. What will happen if it goes, if the en banc panel, if the entire Ninth Circuit votes to take it en banc, then an 11-judge panel will be randomly selected. And again, fate will play a hand in who gets appointed to that. And we will rebrief and re-argue the case. That's the last step before you could conceivably go to the Supreme Court. If he loses an en banc, I don't think he will try and go to the Supreme Court because he knows he will lose there. And what the gun ban lobby folks have been doing is declining to take a case to the Supreme Court because they don't want to make bad precedent. That's what happened in the District of Columbia when the 3-judge panel in there said that the district's no issue CCW policy was unconstitutional. An en banc panel declined to take the case, so there was no en banc review. And then the District of Columbia had to decide whether to take it to the Supreme Court or not, and they decided not to, partially at the urging of states like California, who didn't want bad Supreme Court precedent as a result of that favorable ruling in the District of Columbia being upheld by the Supreme Court.
And it's my understanding that many of other state attorney generals have put in amicus briefs on this case to try to fight for the en banc hearing, because they want the en banc panel to overturn this ruling from the lower court.
Exactly. They want to be able, this is about a preference of some government politicians to be able to severely restrict your right to choose to own a gun for sport or self-defense or to defend your family. They want to make that decision for you. They want to tell you what kind of gun you can have. They want to tell you where you can have, or preferably they would have rather said you can't have any gun. But now, because of Heller, at least you get to have something. You know, from their view, it's you get to have one handgun. They're going to make it a revolver. You have to keep it locked someplace where you can't get to it when a burglar is breaking in, and you can have, you know, one bullet. It's the Barney Fife gun control law. You know, it's ridiculous that it's basically it's ineffective for self-defense the way they want to restrict your right. But somewhere between that and anything goes is what's constitutional and what's not. They just want it to be as far in their favor as it can be, so they can pass as much as they want and get away with as much as they can when they're passing things. So that's why they're weighing in now, because they recognize, again, we talked a bit about the standard of review. The Duncan case is leaning towards, it couldn't completely reject the Ninth Circuit's standard of review that it adopted in earlier cases, but it's leaning towards that text, history, and tradition approach. It's recognizing that originalism is really the right approach that the Supreme Court wants lower courts to take when we're evaluating a Second Amendment challenge. And so that case could turn out to be fantastic precedent, not just for magazines that can hold over 10 rounds, but for the framework for challenging any gun control law that regulates any gun or firearm accessory.
Yeah, and
so
it's a great opinion. If you haven't read it, you should go to the CRPA website or the michelleLawyers.com and read that opinion. It's got a lot of really good information in it. What about the Rhodey case, and where are we on that? That's the ammunition.
This is the challenge to CRPA's challenge to the and Kim Rhodey, who we know and love, the Olympic gold medalist sporting clay shooter. That we won in the district court. That's the trial court. You know, there's district court, Ninth Circuit Court of Appeals, 3-judge, Ninth Circuit Court of Appeals, 11-judge en banc panel. Theoretically, you can even have an entire Ninth Circuit panel with all 25 or however many judges there are hearing a case, and then it's the Supreme Court above that. So there's all these levels of appeal. We won in the district court, the trial court, a great, fantastic ruling that just dissected all the problems with the ammunition, with Newsom's Prop 63, you know, Gunmageddon ammunition background check requirement that bans any mail order or internet shipments of ammunition, bans Californians can't go buy ammunition in Nevada. You know, Californians can't bring ammunition back into this. It just severely limits and has resulted in a lot of people who are not prohibited from owning firearms or ammunition from not being able to get it. And perhaps most significantly, it does what the politicians really intend these things to do, which is makes it so hard. They put so much red tape in between the customer and the product that most of those customers throw up their hands and say it's not worth the effort. And that's really, that's called a chilling effect. That's like when, you know, if there's a right to an abortion, but you ban abortion clinics within 1,000 miles of someone, you know, they're not going to travel the 1,000 miles. That's the chilling effect, which in the context of other rights, the Democrats recognize. They are very much against chilling the right to an abortion. But That's what most of these laws do. Anyway, the court recognized that. But again, the Attorney General's office, the state of California, has appealed that. Those cases have been briefed now in the Ninth Circuit. We're waiting for oral argument before a 3-judge panel. We just filed a supplemental brief the other day because they asked about what historical ammunition laws have there been that might be used as a justification for this current one, and we just submitted our brief in that, our supplemental brief in that. It's an interesting development that the court is asking for a specific issue to be addressed in a supplemental brief that wasn't addressed in the merits briefs. But so we'll see what panel we get. We'll see what kind of questions we get from that panel, and hopefully, CRPA is fighting to hold on to that win as well. And that's another case that could work its way up. The issues are, the standard of review issues are going to have to be resolved. And we've got Rhodey, Duncan, and also Roop now. The Roop case is also, it was just argued before a 3-judge panel. This is the challenge to the California assault weapon law. And we got a panel in that case that was very understanding and asked some very good questions. And the attorney for the DOJ really made some ridiculous arguments. I encourage folks to read that transcript or listen to that argument. But that's another case that could make its way to the Supreme Court. And then there's CRPA has a dozen cases that it's funding and really needs support, frankly. And it's my pleasure to serve as a voluntary president of the CRPA, and also my firm gives the lowest possible rates, nonprofit rates, well below market, to litigate these cases. It's still pricey. I mean, the costs alone, for printing and court filing fees and stuff, it's still expensive. Lawyers who do not have the resources and the depth of field and of their lawyers. I mean, we have some of the greatest Second Amendment lawyers in the country on our staff, including you, Tiffany, as you work your way into that realm, putting these cases together. And we don't know what other cases other groups, nonprofit groups may bring or have percolating up, but certainly our cases are getting the most attention right now. That makes them candidates for Supreme Court review.
Absolutely. I don't think we are going to see a slowing down over the next several months and even into 2021 of some of these cases. I think it's going to be an ongoing battle, and I'm glad that CRPA is fighting those battles for Californians, and I'm very fortunate to be part of the team that gets to work on these cases with you, Chuck. So thank you, Chuck, for your insight today. I would encourage anyone that's viewing this to watch for more information on the ongoing and future cases that CRPA has. And if you're not a member of CRPA, you can join them at crpa.org. And as always, if you would like to support the ongoing litigation efforts that Chuck just spoke about with CRPA, you can get some of those cases to the Supreme Court and help us in those efforts. And you can donate in the link below in the comment section. Thank you for joining us.